How frequently should I be updating my will? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota, and New York City. And today let's take a look at a pretty common question I get, especially when you find that will lying around and realize it's been about 15 years since you signed it, and maybe it's time for an update. It's a pretty common call that I get, and that'll be, I found an old copy of my will. Is it still valid? Should I be updating it? What should I be doing? And so depending upon who you worked with in the past, hopefully you worked with an attorney to make sure that you got the estate plan that you were planning for. And as part of those, you have documents, one of them being a will, and that attorney should be checking in with you to make sure that there haven't been any changes that need to update the will. Now, what commonly happens, however, is that you sign the documents, you throw them in a box, maybe they come up in spring cleaning, or at the end of the year you're going through your files and realize, oh, my will's still there, and that's perfectly fine. Your will doesn't expire. If you don't update your will for 20 years, 25 years, 30 years, whatever it is, the will can still be valid. The question is whether it's still relevant to your estate plan and what you would like to have done. So if you find one of those old wills, or let's say you haven't heard from your attorney in 20 years and you're not even sure where your will is, chances are it might be time for you to update your will. When you work with my office, what we do is we always stay in contact after you sign a will throughout a 3-year period. And then after 3 years, we recommend you come back in and we have either a phone call or we have a meeting and we go through what's in your estate plan. And we usually have to update like a power of attorney or maybe some of the other ancillary documents. But if there's been a change, maybe there's a new grandchild or one of your children has graduated high school or college, we've got some changes we need to make and we know that it's time. So what are the 4 main time periods we see when it's time to update the will? Number 1, when you have a major life event. So especially if you're married and your spouse passes away, that's a major life event, and chances are you'll need to update your will when that happens. If we have new children are born, new grandchildren are born, we have children who graduate college, children who get married, they buy a house, there can be a lot of different, what you would call major life events that should trigger you thinking, do I need to update my will? And so a lot of times what will happen is you can call your attorney and say, we just had another child, do I need to update my will? Well, the way your will should be written, if it's to split between your children equally, then having another child doesn't require you to update your will, but it still might be a good idea. Second scenario I want to look at is when we have a major change in assets. So let's say we have some charitable bequests or we have some accounts that we want to leave to certain people and we no longer have those assets. Or maybe we have totally different life insurance policies now that we want to fund into a trust or do something different with. So when we have these major changes in our assets, we want to consider whether it's time to update your will. This is also a reason why your will normally will not list out all of your bank accounts, because then every time you changed bank, you'd have to go back and update your will because the asset list would change. So instead, what we want to do is check the title on those bank accounts. And if we've had a major change in assets, we want to make sure that we are incorporating that into our estate plan. Number 3, if there are legal changes. So the world of estate planning, our laws stay pretty consistent. There aren't a ton of changes. However, right now we do have one on the horizon for January 1st of 2026 when the federal estate tax exemption is going to drop down. Currently it's over 13 million. It's going to drop down significantly to about 6 million. So we have a big change coming up. If you have assets in an estate that are near that $6 million mark, we want to make sure that we are planning ahead in your estate plan documents. You also may have changes in your state as well. And if there's changes to your local state laws, let's say, for example, you're in a state that doesn't have informal probate, and now they passed a law to allow for informal probate, you'd want to go back and speak to your lawyer about if it makes sense to update your will. Now, if you've been working with a lawyer, they should have advised you of these kinds of changes. So my clients have heard about the upcoming changes to the federal estate tax exemption, and they will hear if there's any difference in the estate laws in any of the states where I practice. So working with a legal professional, they should be keeping you abreast of all these changes to our laws. And number 4 is just the passage of time. Again, as I said, my rule of thumb is 3 years. Some people do 4 or 5. But after about 3 to 5 years, chances are you want to at least check in and check your documents to see whether or not you need to make any changes. So if you've gone through one of these scenarios and you've figured out that you need to make a change, the next question, of course, is how do I go about doing it? And it's a pretty simple 4-step process for this. First of all, talk to your lawyer. If you use one of those online websites, unfortunately, they're not really made for you to go back and forth with them and figure out whether you need an update. So this is a big advantage to working with professionals. Second, you could just create a codicil, which is a fancy legal term for a change to your will. Think of it like an amendment to your will. So going back to the example of your spouse dying, we probably need to remove them as your personal representative, maybe as your trustee. So we can do a codicil or we can do a trust amendment to make small changes. If it's been 25 years and you found your dusty will, maybe it's got some cigarette burns on it, coffee stains, it's in bad shape, it's missing a page, we should draft a new will. We want to make sure you have proper estate planning documents that are legible, that can be given to a court to read. So if it's been a long time, maybe time for a new will. Step 4 in the process, inform the relevant parties. So especially when you have children under 18 and we have guardianship provisions, if we're going to update and make changes, we want to make sure that all the important people in the document know that changes have been made. So there you can see a little bit about the frequency for when you should be updating your will and how to do it. If you have further questions or you want to talk further, my website is 𝙃𝙀𝙍𝙀𝙀. There's a red legal strategy session button on the front page. If you click that, you'll be taken to my scheduling page where we can set up a 15 or 20 minute strategy session on the phone to discuss where you are in the estate planning process and what kind of changes you may need. If you like this video, you can hit the like or thumbs up button below. You can always head over to YouTube or AyersLawTV.com to subscribe for future episodes. And remember, if it's been a long time since you signed your will, now is probably a good time to reach out to an attorney and see if you need to either do a codicil or do a whole new will.